Hello, 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 hello. Welcome back to the live stream, which I think is number 5 or number 6. Yeah, it's still very, very early in my live streaming career. And to the 10 of you that are here, welcome, welcome, welcome. I'm so glad you're here. Listen, there's not going to be like a crazy number of people here today. So if you're here, you should feel free to chat with me. I want you to. I want to try to answer the questions that you have. But I am really excited to get into this lawsuit. This thing it's wild. I want to frame where we're at procedurally. I know I went over it some in the video and in the the video on demand. But I want to make sure that we're all on the same page and we're going to get into the meat of this thing because it is a man, I was going to sound like an old person. I was going to say it was a humdinger. And then I was like, yeah, it's pretty old. Sounds like something Biden would say. And then I was going to say, oh, it's a doozy. Now I think that's also an old person thing. I don't know. But anyways, let's get into it. So I think you guys know that many months ago, a guy named Don Holland sued CryptoZoo and Logan Paul, Danielle Strobel, who's like his kind of office assistant or personal assistant, his manager, Jeffrey Levin, Eduardo Ibanez, Jake Greenbaum, a.k.a. the Crypto King, and Ofer Bentov, a.k.a. Ben Roth. And the lawsuit kind of sat there for a little while, and here's why. CryptoZoo itself, like CryptoZoo Inc., they did not hire lawyers. They did not. You got to get that StreamYard watermark off. Hey, Caleb, listen, Caleb. My producer agrees with you 1000%. No, she's saying I'm missing some zeros. Yeah, very much agrees with you. Although she doesn't like the ha 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 you added to it. It's more of like a finger wag. She wants that thing out of there. Okay. And so do you. She usually gets what she wants. So hopefully she'll get that figured out soon. Not to throw her under the bus. But anyway, the individual defendants, first of all, they did not like line up to get served. And I've covered this in some VODs like way back in the day. It was hard to find them. They didn't want to be served. And but then when they finally did appear through counsel, first of all, their lawyers did not answer for CryptoZoo. CryptoZoo has still not appeared in the action. Their lawyers filed a motion to dismiss and compel arbitration, or a lot of lawyers will turn that around and say a motion to compel arbitration and to dismiss. And what that does is it gives the court the opportunity, this is like the federal court, the judge, the opportunity to examine whether or not there is an arbitration agreement sufficient to send the claims of Don Holland into arbitration, which, as I've explained before, is like a quasi-court, pseudo-court. It's not in the public. If you want to go to it, you can't go to it. It is a place where the defendant or defendants, since it's plural here, pay for wait, oh god, the defendants pay for the judge, which is not actually a judge. I mean, some of them are retired judges, but the defendant pays them for their time. They pay them for their ruling. So you don't got to be a rocket scientist or a genius to figure out that some of those rulings are not going to be right down the middle in, like following the law. Now, a lot of them are, but like the optics of it are that the defendant compels the plaintiff into arbitration when they don't want to go, and then the judge is paid for by the defendant. Not a big fan of arbitration. So before I move on from that, let me run through these comments real quick and see what we are. Yes, I mean, special sauce, the time got changed because you are here now. I said in my video 3:30, but the actual reality is I got to go to my daughter's I get to go to my daughter's basketball game. I actually love going to them. Highlight of my week. They don't let me play in them though. Highlight of my week is a cheer for her, but I needed to leave a little bit earlier, so I needed to start at 3, not 3:30. And so there we go. Let's see. There was something on here I wanted to see. Wanted to give. Does Tom know about the jabs you made at him in the video? And if so, what was his reaction? Well, for that, my friend, we're going to have to get in the Wayback Machine and go to September of 2022, where I was in Los Angeles at the Vid Summit conference, and I was talking with Legal Eagle and Attorney Tom, and Attorney Tom and Legal Eagle, they wanted a photo together, and I took the photo for them. And in order to make Legal Eagle look tall and to make Tommy look short, Tommy squatted down and posed for the picture so that he would actually be about 5'2" in the photo. And it's absolutely hysterical. He put it up. I don't know if he put it in a video or if he made a post about it or whatever. But then a couple of months later, Devin, Legal Eagle, made a video where he's talking about, actually, it was just like 13 months ago, because he made a video, it was around Christmas time, about dangerous toys. And he was talking about like a wooden doll or something, and he put up a picture of Tommy and said, don't worry, Attorney Tom, you'll be a real boy someday, or something like that. Anyways, just digging at each other, super fun. But yeah, Tommy knows generally that in my videos, I lie and say that he's short. All right. So let me, before I get to the next comment, let me say what I want to say. They filed a motion to compel arbitration, and the decision was made, and I believe in this instance, it was made by the arbitrator, not by the judge. I think that's right. But I can't remember. The fact that I haven't read it makes me think it was made by the arbitrator. They got sent back to federal court. The claims against CryptoZoo are arbitrable, which means able to be arbitrated. But the claims against the individual defendants, which is what anyone cares about. I mean, CryptoZoo doesn't have any assets, right? I mean, it's not like it doesn't have a brick and mortar business. Everything that it has is like kind of, it's basically a pass through. And to make that point more clear, paragraph 12 of this lawsuit on page 10 alleges essentially that. In fact, I'm going to go ahead and read it right now and explain it so that you guys know exactly what they're arguing. This is what paragraph 12 says. Defendants were never permitted to solicit investments from the public related to CryptoZoo, meaning they didn't have a legal right to do that. Then this is where they get a little saucy, and I'll explain why. The entity CryptoZoo Inc. was created to serve as a fraudulent vehicle for the sole purpose of selling patently worthless, unregistered Zoo tokens and CZ NFTs to enrich CryptoZoo's founders, promoter, manager, and affiliates. Absent defendants' fraudulent conduct and misrepresentations, Zoo tokens and CZ NFTs could not have been offered and sold to investors at any price. Okay, there's a couple things going on there, but this is a very critical allegation, because one of the features of the common law that we have here in the U.S., and a lot of it has been made permanent by statutes, or not made permanent, but made it's been codified. It's made uniform by statutes, is that ordinarily the owners of a corporation are not subject to liability for the acts of a corporation. The corporation acts as a shield for personal liability, and that is one of the main features of corporations and why people like them. People who are doing business. There's also, I mean, there's a bunch of other benefits, obviously, including that you're able to extract and remove a whole ecosystem of financial transactions and have it be assigned to a person. And that's why Mitt Romney once famously said, hey, corporations are people too, my friend, which did not land as well as he thought it would land, but has been something that I've been laughing at since whatever year it was that Mitt Romney ran for president, and he had binders full of women. His words, not mine. But anyways, there is a way for plaintiffs to get around the corporate structure. Because ordinarily, like if you sued, Walmart for, let's say you were shopping there and the store caught on fire and you had smoke inhalation, you were hurt or whatever. You sued Walmart. You would not also sue the officers and directors and owners of Walmart. You wouldn't sue the founders of Walmart or the majority stakeholders. You'd sue Walmart, the corporation. And many people have. They are a slow-moving target for litigation. But this isn't just against CryptoZoo. This lawsuit here is all against these 5 other individuals. And the reason that chapter, yeah, it's an entire chapter. It's 6 lines long. The reason that paragraph 12 says what it says is to give the court a legal basis to do something called piercing the corporate veil. The veil is the thing that separates the owners of the corporation from the public, right? So the idea is that if you have a fully funded corporation in place and it is conducting lawful business, then the owners who are behind the veil, they're on the other side of it, can't see them, can't sue them, can't get money from them, etc. This lawsuit is alleging, and this was present in the first draft, the first version of the lawsuit as well. It says that the entity CryptoZoo was created to serve as a fraudulent vehicle for the sole purpose of selling worthless items to enrich the defendants. Now, the individual defendants. It reads like a burn, and it is, but it's not there for that purpose. It's there to make a factual assertion that would allow the court to make the legal determination that the corporate veil can be pierced. Because honestly, suing CryptoZoo as an entity is not something that most plaintiffs' lawyers are going to get out of bed for, because CryptoZoo doesn't have any money. And the point that I made at the end of the VOD today is not something that we can skip over. The success of Prime is the absolute best news for Don Holland and the other 119 plaintiffs in this case, and Attorney Tom and the lawyers that he's working with, and everyone who plans to be a passive member of the class, which I hope everyone who's eligible will be. Because they're making a killing off of Prime. It's fantastic. I mean, the drink's not fantastic. I don't know. I've never had it. I read an article that says that it's filled with electrolytes that you don't need. And if you're into electrolytes, you should really drink Gatorade. It has like the scientifically best formulation of them or whatever. But listen, you're not here for my athletic coaching. So let's get into some comments, because I've talked too long without them, I think. At least that's what I'm hearing locally. Caleb asked, do you think Logan's argument that it wasn't him who profited, but his friends who scammed his fans who did, do you think that he wouldn't be charged with anything criminal, but his friends only? The answer to that is no. Well, let me back up and say, I don't think anyone's going to be charged criminally. This comes up from time to time in my videos and in the comments. He should be. This is a perfect storm of criminal behavior and civil liability. And I honestly think if he weren't famous, he might have already been charged. And I don't mean that as a burn on the FBI or the SEC or the DOJ. It's just like what he's done, like setting up a business that says it's going to do X and then it doesn't do X, and then continuing to lie about it and keep saying, long after you know that it's not going to do the thing that you said it's going to do, continuing to say that is such a scam that if he weren't wealthy and he weren't famous, I feel like I want to say the SEC would have already come down on him, because it's like very straightforward. Now, there is some murkiness, and And Attorney Tom and the other lawyers in this case do a great job of kind of trying to shed light on the fact that this area of NFTs and the I don't want to say it wrong, the zoo tokens is an emerging area of the law, in that, like, historically the SEC has monitored and wow, it's a word that starts with an R. I'm doing it again. They've monitored and they've regulated. I told you it started with an R. They've monitored and regulated and prosecuted for violating things like stocks, bonds, other commodities, futures, derivatives, stuff that everyone has historically agreed is subject to regulation by the SEC as a security. There is really no other category for these things here than being securities, but this lawsuit goes out of its way to make clear that in the eyes of the court, this should be determined to be a security, and not for nothing, okay? Some of the causes of action here are, let me rip forward to, this is near the end of this intro section, and I want to make sure, actually, you know what? I can go back to the table of contents and it'll line it out here, because this is an improvement on past litigation for these types of claims. Check it out. Violation of Section 10B and SEC Rule 10B5, violation of Section 20A, and commodity pool fraud violations of Sections 40 and 22A of the Commodities Exchange Act. So I say that because I want to make sure that you all understand that this is actually an emerging area of law. And Caleb, to your question, I don't think there is a legal distinction between Logan and the other defendants where some of them would get charged and he wouldn't. I think it's just that none of them are going to get charged. And honestly, I don't mean this to be negative in any way. This lawsuit, especially that it's filed by really serious attorneys who are the guys that Tommy is working with, they know exactly what they're doing. This is a fantastic lawsuit. I just don't see a future where they don't win this case. Now, I got to hit pause and say, if you've been on my channel much, you know that to me, a win includes a settlement. I don't need you to go to trial to win. If the defendant pays money, real money, then that's a win. They're going to win this case. There's not a 1 in 500 chance that they don't win this case. The defense of this case is a joke. And that's one of the reasons, in my opinion, that Logan Paul has done this buyback program, because let me explain a little bit about the economics of class actions. And if you know this, stop me. One plaintiff or 5 plaintiff or 10 plaintiff file a lawsuit, and let's say there's 1,000 plaintiffs in the pool. Of course, in this case, the pool is way bigger than that. It's like 10,000 people. But whatever it is, it's a number. Let's say it's 1,000. When you are either getting a settlement or getting a judgment from a jury, the value of the entire case is predicated on the number of participants. I shouldn't say participants, members of the class times the average value of the claims. If 200 people out of 1,000 sign these waivers, then the value of the case goes down by 20%. Even though Paul might only pay, let's say if that happens, he might only be out, like in my scenario, he's only out $230,000, okay? Because that's 1/10 of the money that he says he set aside, and it's 1/10 of the size of the proposed of the possible pool. He spends $200,000 to get 1/10 of the value of the class action eradicated, eliminated. Well, this case isn't going to settle for $2 million. It isn't going to settle for $10 million. This case is worth, man, I don't know. It's worth more than $25 million. That doesn't mean necessarily that they're going to settle for that at a minimum, or if they went to trial, they would get that. Just like looking at it on paper, it's easily worth that. Let me get into some comments real quick because I've been away from them too long. Yeah, Brandon said, he quotes Logan Paul as saying, those who gamble on crypto, however, the way I see it, he promised a product, the game, and he paid people for the parts needed to play the game. That's a product, not a gamble. I totally agree. But so over the Christmas holidays and New Year's holidays, my family and I, we played a couple of games, but one of them was Codenames. I don't know if you played Codenames, but you know, you get this list of words and you're not allowed to say them. You write down one. You've played Codenames. There's nowhere in the advertising for Codenames that says, you know, buy this game, you'll make money. Like literally no games say that. It's you can never ever say that with a straight face about categories, Trivial Pursuit, Mario. I mean, that's not how it works. And so it's that right there. It's that statement, and the lawsuit hits that quote over and over and over. I was actually thinking about this morning when I was studying the lawsuit again. Well, how would the lawsuit read if they didn't have video of Logan Paul saying it's a really fun game that makes you money? The answer is I don't know. I kind of teased that around in my head for a minute, but the success of this lawsuit, which they will have success, is going to be driven in part by the fact that he did say they're going to make money playing the game. It's just, that is the weirdest thing that you could ever say about a game, because then it's not a game. It's an investment. And so it's an investment product that he says is fun to use. It's not a game. Let me get down here a little bit more. If shortly after means like 10 years, can Logan be sued or can he not because he never set a deadline? So that's a great question. Courts will, and thank you for asking it. Courts will imply a reasonable missing term, and the timeliness of an action is a missing term. Now, I said in the VOD that this is it's like a legal transaction, because it is. It's a contract. A waiver is a contract. I offer to buy your claim from you for X dollars. You accept. These are the terms. The courts will imply a reasonable term, which is going to be like 30 days or something like that. But it's just so shady. I can't stand it. Let me scroll down a little bit. Paragraph 12 could lead to Logan's paragraph 13. Yeah, so for those of you who aren't familiar with bankruptcy, that is a lawyer joke, because he could be personally bankrupt because of the judgment that he's going to suffer in this case. That is a possibility. I don't bet on it because the value of Prime is so incredibly high. He'll find bankers who will get him out of this mess, even if he doesn't have cash on hand, and that is fine by me. Okay, let me scroll a little bit faster. Zoo holders better watch out what they are into this abomination of settlement proposed. But yeah, I totally agree. I mean, yes, if you are a Zoo token owner, I mean, look, this is not legal advice, but don't do it. It's like really, like, unless you are like in your heart and soul opposed to participating in a class action or in litigation, that's the only reason you should take his money. The thing about getting a refund that matches your eviction amount in my video, that was a joke. It's a joke because you don't even know if he's going to pay it. He has in his sole discretion, he can pay or not pay, and we don't know when he's going to pay. Let's see. You have asked Johnny, if you signed the buyback form, but you will not send them in NFTs, does this still waive your eligibility from the lawsuit? Great question. That's a tricky one. And the answer is probably. It's so convoluted, but here's the short answer. If they wanted to sue you, if Logan wanted to sue you to compel you to send the NFTs so that they could send you the money, then they could enforce that waiver agreement. That would be incredibly expensive and it would be done by everyone. But yeah, you could do that. Yeah. Yeah, John, I addressed why they're not charged earlier. I think it's that the SEC is really scrambling to figure out how to enforce the proliferation of scams that came out in the crypto world in that 4 or 5 year period. Gary, listen, you ask, is crypto a young person's game? I thought it was. I don't know. I mean, it just doesn't appeal to me. It just seems so speculative that it just I don't know. It doesn't appeal to me. Let's see. Yeah, so Caleb asks whether Logan would have assets in his personal name. The answer is, if you get a settlement agreement done with him, it's going to be written in such a way that even the other entities, anything that he controls, is going to be subject to pay them. That's number one. Number two, if you get a judgment against him, let's say he can't figure out a way to settle it, you can just go actually take the assets that are in his name, aka his stock in Prime. So you don't get money. You just go own Prime or some other asset of his. Like it will jam him up if it goes to judgment. It will jam him up. Okay, so I like this question. Hear me out. If we bought a lot of Prime and made a whole campaign around it to encourage higher damages for the victims, would that be viable? I mean, I love the spirit of this question. The Prime enterprise is doing so well by every report that I've read that I think that you should focus on drinks that are actually healthier for yourself. And there's a faster way to put money in the hands of the victims, which is to do like a Kickstarter or a GoFundMe. Don't filter it through an overhyped energy drink that's probably not that good for you, and then into Logan's hands, and then eventually into the hands of the victims. So let's just give the victims some money. That's what I would say. Yeah, let's see. So Tcon 321 says, I really hope the Pauls lose everything. So I've asked around. I don't think that Logan Paul and Jake Paul are the same person. They're brothers, but I think they're on the different side of a lot of issues. Like, I know a lawyer who works closely with Jake Paul, and he describes someone who is very, very, very different than Logan. And so I don't know. I just don't wish ill will on people. Like, if Logan Paul owes this group of people $50 million, I want him to pay. I don't want him to lose everything. I don't want him to keep scamming people. And if you read the lawsuit, especially around paragraph 16, they say that CryptoZoo is a scam, and it follows after Dink Doink, Liquid Marketplace, F Elon, Emax, OMI, and Elon Gate, aka not his first rodeo, not his second rodeo either. So I get it. I mean, if you were one of the victims, maybe you'd want him to lose everything. But look, revenge, that's not a value that I have. I don't think that vengeance helps people in your life. I think that forgiveness will lead to a happier and fuller life. And so that's what I'm into. Let's see. Okay, so I got to get into the complaint to answer this question from Snorlax. Would their punitive damages be awarded on a win? Potentially. So the answer is this is filed as a class action, and punitive damages are not typically awarded in class action cases. But they have pled this with the desire and the aim to get punitive damages. Now, because they have 120 people in this case, it's a possible situation where they get there's 3 possible outcomes. No, 4. An agreement is reached, and it's not really clear if any of the money that's paid is punitive. That's actually the most likely outcome. That's number 1. Number 2, they go to judgment, and no punitive damages are awarded to anyone. That's probably the second most likely outcome. But it's way, way down the list because the settlement's the most likely. Third is that they go to trial. Punitive damages are awarded for the class representatives, but there's insufficient factual evidence for the class members. That could happen. And I think I ran through all the options, trying not to mess it up, but I'm pretty sure I did. Yeah. Punitive damages are fascinating. Juries will get riled up, and appropriately so, and they will award, like I read one recently where a jury awarded like 1.3 billion with a B dollars. Maybe we did a video about it. Did we do a video about it? A jury awarded like $1.3 billion of punitive damages. A judge came back in after the fact and reduced it to, I think, like 1.3 million. They reduced it by 999 1,000ths. They gutted it. Punitive, what is it? Oh, there you go. They reduced it from 25 billion down to 25 million. It's the same fraction. It's 1 over 1,000. That's brutal. It's frustrating to me because if the facts are so bad that a jury is willing to award $25 billion, I think the judges should kind of stand aside and say, oh, well, why overturn the judgment of the jury? The reason they do it is they say, oh, the jury got so inflamed, we can't trust them, yada, yada, yada. But I don't like that at all as a general principle, because if the facts are so bad that you can inflame a jury, then so be it. Defendants ought not be out there committing such bad facts that juries get inflamed, at least in my opinion. That's how I see it. From 8 minutes ago, Ancient Red Dragon. Yeah, I talked about piercing the corporate veil. That actually is going to be a really big element, both in discovery and in the trial, if this case were to go to trial. Discovery is where they get to take depositions of the defendants and potential witnesses, and the defendants get to depose Don Holland and the other plaintiffs. I think it's going to be a stupid waste of time to depose them, but man, defense lawyers love to take depositions because they get that cash. They get to charge so much money. They'll, like, let's say they interview someone, with Attorney Tom and the other lawyers present. They interview them for 4 hours. They will bill their clients like for between 8 and 24 hours of preparing for that interview. And they're charging them like $500, $600 an hour. It is a lot of money. But yeah, so piercing the corporate veil is going to matter here. Let's see. I want to answer this question. Can he deny all but a few claims, like deny most of them, but only buy back 10? Yeah, but it doesn't do him any good to do that, because unless he pays you for the buyback, then your claim's not waived and you're a member of the class as long as you don't opt out of the class. So I don't think that would be a thing that people should be concerned. Oh, this is a great question. Also, would the original investors be settled with the form of payment that they use or with US dollars? So the answer is almost certainly US dollars. Now, that is a point that can be negotiated between the parties. But if this is settled on a class-wide basis, which I just don't see any reason that it would not be, then a court is going to have to review the agreement and approve it to make sure that it's fair to the absent class members. And they do this by the parties will tell the court we have an agreement, and then the court will authorize them to send a preliminary notice to the class members that says, hey, I got to have your attention. There's been a preliminary agreement for settlement, and the terms of it are in this notice. And if you object, you have to come down to my courthouse, actually, physically come to my courthouse. This is in Austin. I think this is filed in Austin. To come to my courthouse on such and such a day, let's say 1 p.m. on July 1st, and tell me what your objections are to the agreement. And then people rarely object. The judges typically approve and do a final order of approval at that time. The judge is not going to approve an agreement that allows for payment using a form of currency other than US dollars unless the plaintiffs make a compelling case that all or part of it should not be US dollars. It's a fantastic question. But I mean, you can see it even in his buyback program. He's using digital assets, ETH, to get a bargain because the value of ETH has gone down. Let's keep rolling here. Yeah. Okay. So Brian's question is similar to a couple that I've addressed already. It's a slightly different version, and that's why I'm putting it on the screen. If you sign the buyback form, but Logan never actually pays you back, are you still waiving eligibility from class action lawsuits? Heck no. Jump on that thing, get in there, and get your money. They would never win a motion to exclude you under that circumstance. Of course, they could pay you later, and then you'd be out. But let's see. Does Logan Paul have the personal funds to financially make things right? If so, why would he not? Listen, let me tell you what the allegations are. This is not me talking, okay? These are the allegations. Logan Paul is now a career scam artist. That's not me. That's paragraph 16 of this lawsuit, okay? They're going to try to prove it in court. That's fine. It's not me talking. That's what the lawsuit says. Let's assume, for the purposes of this discussion, that that's true. That's the answer to your question. What he says, he literally says in his tweet, I intend to make people whole. What? Not even close. I mean, Coffee's point is that it's basically 1/8. I don't see how it's that high. And I'm not going to quibble with him because that dude does some really stellar research. And if he says it's 1/8, that's fine. But it's not trying to make someone whole. And so could Logan have settled this class action case before now? Heck yes. I am telling you, as a plaintiff's lawyer, which is what my career has been, we're always ready to talk settlement. Litigation is so expensive. There's always a risk of loss. There's always the risk that your clients lose interest or that they die. The right thing to do by your clients and by the class is always to pursue settlement. So you should understand this, and I'm going to say this, and this applies to every single case that you ever hear about from now until you die. If the case is not settled, it means the defendant is unwilling to pay. Period. That's what it means. It means they're either not willing to pay at all, or they're trying to get something over on the class or the plaintiffs. It doesn't have to be a class action. See, yeah, I like this. Crypto is nothing more than digital baseball cards. I agree. Baseball cards, I think, are a young man's game. I don't know. I collected football cards when I was a kid, but yes. So let's see. Will laws change? Yeah. Oh, 100%. Will laws change to make these scams criminal, or these scams criminal, so people like Logan Paul could face jail time? 100%. Now, you can sit around and wait on the U.S. Senate and the House of Representatives to do this, but it doesn't have to be that way. On a state-by-state basis, they can 100% criminalize these sorts of scams, and they should. And And there's nothing stopping them. The political will to decriminalize or not make criminal or not allowed to be criminal scams like this is not there. If someone who had some money put a little bit of lobbying into it, and I'm not saying it couldn't be done grassroots without paid lobbyists, but if someone would just put a little bit of money into it in one state, you could get some very clear legislation passed that would make this sort of scam straight up criminal. And then once one state does it, as long as it's not California, because most states are pretty loath to follow the California's lead in terms of legislation, just because they're kind of doing their own thing. Not that it's all bad, but it's their own thing. But if you could get like a state in the middle of America to criminalize this, totally, you be making some progress. Ancient Red Dragon says, I'm sure between his appearances, his drink, his podcast, etc., he could pay. He can. It's not a money issue. He's holding on to that money, hoping that people lose the will to pursue him. And I hope they don't. Hey, now, Lucy Herb. A jury should award America's attorney with the best video background. 100% agreed. This is all because of my awesome producer. I didn't make this. She's the best. She deserves the love for this. It's fantastic. I just agree with you 100%. And Dojo, you are right. Punitives are sometimes capped by law. They are in a lot of states. Even in some states, compensatory damages are capped by law, which boggles my mind. But like in Texas, if you have a surgery and they're supposed to say amputate your right arm and they amputate your left arm, the most money that a jury can award you is $250,000, even if they cut off your wrong arm. So after that surgery, you got to get your other arm cut off, and now you have no arms, and the most that's worth is $250,000 in Texas. I would not have important medical procedures done in Texas if I had any chance to do them elsewhere, because the caps on even compensatory damages in Texas are, well, the caps are punitive. Boom. Uno reverse. All right, let's see. Punitives were capped at $600K and Debt v. Heard. Yep, there are caps out there. You're right. And T-Con, just so she sees that people are loving on it. Yeah, I'll put you up there. So let's see what else we have here. So let's go back to the lawsuit. I appreciate the comments. I want to get through Logan's cross-claim against his co-defendants is wild, because he was one of the people who said, send us to arbitration. Well, then the ruling came down that they were going to have to pay for it, and because it was consumer arbitration and they want to pay for it, so they're staying in court. And he's so ensconced in court and so happy to be there that he sued Jeff Levin and Danielle Strobel. I think that's right. You know what? I'm going to have to look at it again. I'm not sure who he sued, but I know he sued at least 2 of the co-defendants, which is crazy. I want to look at paragraph 3 of this complaint real quick, the amended lawsuit, because it's so crazy to me. If you gotta put on your thinking cap. This is what paragraph 3 says. Ultimately, defendants never released the game. Oh, we know that. Although allegedly it was completed in, quote, early in 2023. This is despite defendant's statement from 2021 that it had already been completed and tested. Now, the point they're making is that they were stringing people along. And if there's a savage insertion of a screenshot in the amended complaint, which points out that the volume of Zoo token transactions went way, way, way up following CoffeeZilla's expose, which it makes me so sad. Like, Coffee made that expose and it's brilliant. It's shown so much light on Logan's alleged scam. Can I just say the word alleged and let's have it just be valid for everything that I say, including stuff I've already said? in this video, I think that we can all agree that. I'm always saying alleged from now on. Okay. More people, because Logan responded by saying, no, this thing's still under production. It's going to launch early soon. More people bought into the game. It breaks my heart. I mean, all Coffee wanted to do was protect people. And then the volume of trading on CryptoZoo went way, of the Zoo tokens went way up. That's terrible. But anyways, they say, despite defendant's statement from 2021 that had already been tested, the first of these public statements was made during the public announcement of CryptoZoo on August 18, 2021 by Logan Paul, the majority owner and online celebrity, via his YouTube show Impulsive, claiming that the game was, quote, so fun and a really fun game that makes you money. Now, I know that he said this, and I know that it's incredibly offensive to people with common sense that something is merely a game if it also makes you money, because code names, categories, Monopoly, those don't make you money. No one ever says that they do. Games don't make money. Okay. But I kind of wonder if the lawyers here aren't a little bit out over their skis, and just a hair. And let me explain why I think that. You know, when you want people to buy something, let's say it's a hamburger, and you say you're going to get this. Let's say you run an ad on the radio at 2 p.m. that says, come in from 6 to 10. We're going to serve you the tastiest grilled burgers you've ever had. Well, it's not wrong at 2 p.m. to claim that the burgers are grilled and tasty. It's like puffery. I mean, we all know that the people say things when they're in promotion mode that aren't meant to be taken verbatim. And so I don't necessarily agree that it is self-evident that it's fraudulent to say that the game is so fun and that it's a really a fun game that makes you money. That's not fraudulent if it turns out to be true. It's hard to how can I put this another way? It's like, if you make good on the puffery, then the puffery is not fraudulent. It's just puffery. And so it's not necessarily the case for me, if I'm on the jury, that just because you proved that he said these statements and the game had not yet been played, that it was fraudulent. It's just puffery. The fact that it never became a game that was fun, that's what makes it fraudulent. And in the next paragraph 4, this is what the lawsuit says. Paul's 2024 tweet, he's talking about the one from a few days ago, right, where he launches the buyback program, revealed defendants' promises and representations that they had individually played the CryptoZoo game or that it was functional, made before the game was allegedly completed in early 23, were false. I don't know. Like, if I tell you at 2 p.m. that the burger that I'm going to grill you is super tasty, that's not fraudulent if I end up serving you a really good burger. I don't want them to lean into this in the case, because I don't think that's what the case is about. I don't think it's the timing of the case that makes the timing of the statements. I don't think it's the timing of the statements that makes them fraudulent. I think it's the fact that the statements never became puffery. I mean, never became true. They went from puffery into lies rather than from puffery into promises delivered. Let me make sure I haven't missed much here. I did lose some down here. Okay. Why, Mark Hutt says, why would he be suing the other parties but have them waived in the legal document? Yes. So I was just addressing paragraph 4 in the lawsuit. This is paragraph 5. Listen to what they say here. Further, Paul attempts to distance himself from the fraudulent scheme he instigated with the other founder defendants by blaming, and this is the quote, bad actors who did steal money and who betrayed the CryptoZoo team while internally sabotaging the game, referencing his contemporaneously filed self-exculpatory cross-claims against defendants Ibanez and Greenbaum. That's right. That's who he sued, not his manager and his assistant, but the guys who have the fake names, Crypto King and Lordzilla or whatever. I don't know. What is the name? Oh, Ben Roth. Yeah. It doesn't matter. He sued Ibanez and Greenbaum. Then it says, to create more distance from his bad acts, Paul also offers to buy back CZ NFT tokens at their original purchase price, which we all know is a lie. They're not purchased they're not buying them back at the original purchase price, claiming it's a way for him to make whole those who intended to play the CryptoZoo game. This is crazy. Now, I want you guys to stay with me here on this, because this is a big deal. This distinction matters a lot. He got outed in December of 22 by CoffeeZilla. Agreed? Yes, we all agree. Thank you. Both hands up. Everyone agrees. Okay. Days later, he makes a video where he says, oh, the reason it's not up is the programmer stole the code base from me. Now, if that's true, which I'm not saying that it's true or not, although Coffee interviewed the people and they're like, we didn't steal the code base. He quit paying us, and so we quit working on it. I don't know. I'm sure there's plenty of shades of gray in there. But let's just assume that statement is true. It is a complete fraud for him at the exact same time to say the game is still under development. We're going to launch it later in 23 or early 24, which is exactly what he said. If the code base is gone, if the game is stolen, if it can't be posted, if it can't be played, it's just a lie to say that the code base was stolen and also we're going to put it up. I don't think they hit that part hard enough in this lawsuit, but only a fool would believe that on the one hand, the code base is stolen, and on the other hand, he's got the code base and he can put it up. And he can put the game up. To me, it's just that's like a joke. But Mark, you were asking a slightly different question. And Alexis says he's making a face, which I think is a farce, that everyone's guilty except him. Yeah. So, but what's weird is if you participate in the buyback program, you have to waive your claims against his co-defendants. He is suing his co-defendants. He's suing them. But he wants you to not sue them. I mean, it's the most kind of incestuous, brother-in-law bargain I've ever seen. It makes no sense to say, I'll give you some money, and I swear the money is only coming from me. But if you participate in the buyback program, you won't be able to sue the very people that I'm suing. To me, that is so shady. If this was a real game, did he have to follow rules and regulations? Well, so Call of Duty is a different type of game, and you don't make money playing it. The game is written, it's programmed before it goes up. And when they iterate, when they put out a new version, it works and the old one doesn't. And it's they're replacing it. And so he never had a game. It wasn't. And so when he said it's a really fun game, it's so fun, and it's a really fun game that makes you money, I think he's talking about the concept of it there. Those could be true statements if they ended up being true. They're puffery until then, and when they end up not being true, then they're fraud. They're lies. Yes. Okay, Tabitha, this is the point I'm making exactly. It's both stolen and being released. It can't be both. But that's the position that he took. Now, cleverly, he took that video down, like, I don't know, within a day or two. I thought it was up longer than that, but in the lawsuit itself, the new version, they say that his sort of like what I'm going to do to make things right video from January of 23 was only up for a day. I'm sure they're right. Yeah. All right, so let's get back into some more things about the lawsuit. We'll move on to paragraph 6. I've got 5 minutes because I've got to get on the road to my daughter's basketball game, and they're going to win. I promise you, they always win. No pressure, girl, but they always win. She's not watching right now. All right. So paragraph 6, I love this. So they're going after Paul so hard. Here it says, yet an inspection of Paul's quote unquote buyback program terms and condition reveals his promises to again be misrepresentations. The terms and conditions do not contain the term original purchase price. That's from the tweet. He literally makes a tweet that lies about his own program for buying back. He says he wants to make them whole, pay the original purchase price. It's insane. It's not the original purchase price. And instead, he offers a flat exchange of 0.1 of Ethereum for each CZ NFT returned. Now, that's not what people paid for them, number one. And number two, Ethereum's value has gone way, way down. It's like, I can't actually understand. Part of me wants to think it's dumbness, but like he's obviously got some intelligence in some ways, in some areas. So I don't know. I don't know. So anyways, let's skip on from there to paragraph 8 of the lawsuit, which is kind of what I've been hitting on for a while. This is the last sentence in paragraph 8. They say, defendants promised one thing up front. So fun, really fun game that makes you money. Did something completely different behind the scenes for years. That's correct. And now attempt to walk back their misrepresentations and fraudulent inducements to avoid liability. I mean, that's it in a nutshell. And that is how they broke the law. It's just, they really, really messed up. So let's get into some of the classes that they are seeking in this case. This is super clever because when they had Don Holland as the only plaintiff, they were limited to the type of transaction that Holland participated in. And I don't remember from reading it at the time which one that was, but there are actually 4 types of transactions that are being covered now. So let me get into them real quick. Number 1, purchase Zoo tokens on their public release date. That's one class. Number 2, they purchase CryptoZoo NFTs on their public release date. That's a different class of people that can be represented either by Holland and or by one of the other 119 people in the lawsuit. Class number 3 is purchase Zoo tokens or NFTs directly from the defendants during the class period, meaning that they bought them not during the release, but in the follow-on after that, because that's a different type of damages, and there's some different legal issues there. And then class number 4, purchase Zoo tokens or CZ NFTs on the open market during the class period, meaning not directly from the defendants, but from other people. Again, a different calculation, a different type of damages. And I know that's hyper technical, but these sorts of cases are hyper technical. Like it takes, it's really great for Attorney Tom and the other lawyers working on the plaintiff side of this case that they were able to amend and add all of these other plaintiffs, because you can both broaden and thicken the network of people who cover the claims so that your class action can be more what is the word I'm looking for? More thorough. Okay. Real quick here. No, Logan Paul should not have hired me, and that's not a funny joke. No, actually it is. Let's see. Let's see. Creating the game basically serve. Okay. Yes, I love this. Sorry if I missed something that I just hopped on to him stating he will not be creating the game basically serve as an admission that he defrauded. Also, good luck to your daughter. Ball out. She always does. And her best friends are her teammates. And that is the way to live life. And that's the way it is for me at work. I love the people that I work with. And man, it's so fun to be on a team, and kids are lucky and they don't know it when they get to be on a team and like strive for a goal together, which is what we do here on the channel and also next door at the law firm. And I love it. Yes, he is admitting that it's a fraud. He has to pay every dollar back. He has to. It's completely absurd that he's offering a partial buyback. It's actually crazy. I don't understand how anyone could take it seriously. It's so batty. Now, Logan or his lawyers, if y'all are listening, everything bad I said about you was all allegedly. I don't know. We'll see what happens in court. I love you guys for real. Thanks for coming. Make sure you subscribe to the channel if you haven't, and I will be back soon. I got another video coming out. What day is today? Today is Tuesday, friends. I got a video coming out at 2 p.m. Central Time on Friday, and it's going to be about, oh yeah, it's going to be about the cross claims. So it's going to be what he's saying about his other co-defendants, and I'm really excited about it because he basically has admitted that he was part of a fraud. He's going to have to lay everything at the feet of his co-defendants, and we're going to get into what does it all mean. Like, just because he proves that maybe they were more at fault than he was, does that mean that Don Holland and the other 120 or the other 10,000 people can't get the money that they want from Logan? Do they have to only look at the co-defendants if he wins his claims? That's what we're going to look at in the video. It's going to be awesome. And I am also reminded to tell you that if your question did not get answered, comment down below and I will answer it. Okay? Thank you very much. See you later, guys. I'm hitting the end stream. Bye-bye.